Hey everybody, welcome back. In this video, we're going to review all your required Supreme Court cases, so let's do it. Okay, so here's the plan for this video. We're going to go over the facts, the holding, and the constitutional principle of all your required cases. Everything you need to know, nothing you don't. So let's start off with McCulloch versus Maryland. The facts in McCulloch were that several states, including the state of Maryland, placed a tax on the U.S. National Bank. Now this leads to two questions. First is, can Congress even create a national bank in the first place? And then secondly, can a state tax the national government? Well, the court's holding answered those two questions in the following ways. It said yes, Congress does have the power to create a national bank, and no, states cannot tax the national government. Now, the constitutional principle, the reason for the holding in that case, was, first of all, when it comes to creating the national bank, Congress can create a national bank because of the necessary and proper clause, also known as the elastic clause. This gives Congress implied powers. So in other words, they can do things that aren't directly written in the Constitution because of the necessary and proper clause. This expands Congress's power. The second question, they looked to the supremacy clause, and they said that the federal government trumps state governments when the two come into conflict, so states cannot tax the national government based on the supremacy clause. Another victory for the national government. U.S. versus Lopez is our other federalism case. Now the facts for this one is that a student in Texas brought an unloaded gun to school, and he was charged with breaking the federal Gun-Free School Zones Act, which made it a crime to bring a gun to school. The issue here is whether the federal government has the power to make that law or not. The holding in this case was that the Gun-Free School Zones Act was unconstitutional, because possessing a gun does not substantially affect interstate commerce. This leads us right to the constitutional principle, which is that Congress was here exceeding the powers given to them by the Interstate Commerce Clause. They are able to regulate interstate commerce and things affecting interstate commerce, but guns at school doesn't substantially affect interstate commerce, therefore this was taking that Commerce Clause power too far. The other way we can look at this is if they ruled in favor of the 10th Amendment and the reserved powers of states, reminding everybody that certain things belong to the states and they're not the job of the national government. Next up is Baker versus Carr. And here, residents of the state of Tennessee allege that the way that the districts were apportioned was very uneven, so that one person's vote counted a lot more than another person's vote in another district. Now, the court here really had to decide, is this something that a court can rule on? And the holding in this case said yes. Issues of apportionment are justiciable, meaning that they can be decided by a court. The reason this matters is that it leads to the one person, one vote principle. The idea of equal representation in the House of Representatives. So districts have to be of roughly equal size as a result of Baker versus Carr. And the constitutional principle for this case is the 14th Amendment's Equal Protection Clause. So guaranteeing that states can't deprive persons of equal protection under the law, people have a right for their votes to be equally counted according to Baker versus Carr. Shaw versus Reno is another voting case. In this case, the state of North Carolina intentionally drew a very gerrymandered, bizarrely drawn district with the express purpose of increasing minority voter representation. The holding in this case says that you can't do that. That drawing a district based only on race, even if it's to increase minority representation, is not permissible. Now this was a very heated decision, it was a 5-4 case, but the majority here used the Equal Protection Clause as the constitutional principle, arguing that based on the colorblind ideal of the Constitution, you cannot look at race when it comes to drawing congressional districts, that violates the Equal Protection Clause. Marbury versus Madison is perhaps the most famous case in American Supreme Court history. The facts of the case involve a man named William Marbury. He was one of the midnight appointees by President Adams before he left office. Now, when the next president, Jefferson, and his Secretary of State, James Madison, got there, they refused to give Marbury his job, so Marbury sued. The holding in this case said that the Judiciary Act of 1789 was unconstitutional. The reason that mattered was that that was the law that Marbury was using as basis for why he could sue James Madison. That is the first use of judicial review. So really here the court granted themselves the power of judicial review. Remember, that power was not specifically given to them in the Constitution, but here in this case the court claims it for itself. The constitutional principle that judicial review is based upon is the Supremacy Clause. Well, the U.S. Constitution supersedes congressional laws. So if the two come into conflict, a law versus Constitution, the court has to say that the Constitution wins. Next up, Engel versus Vitale. Public schools in New York would begin the school day by inviting students to recite a non-denominational prayer. The court held in this case that states cannot hold prayer in public schools, even if that prayer is non-denominational and even if that prayer is voluntary. The constitutional principle that this case is based upon is the Establishment Clause. It says the Establishment Clause does not allow the government, including state and local governments, to promote religion, and in this case, that prayer in public school would be seen as violating the Establishment Clause and that separation of church and state. Another religion case is Wisconsin versus Yoder. And in this case, Amish families in the state of Wisconsin did not want to send their children to high school because they believed that the things that they might be taught would go against the values and the religious beliefs that they were instilling in their children. And in the holding, the Supreme Court ruled in favor of the Amish families. They ruled that the Amish families had a right to not send their children to school and that this is based on their religious rights. Specifically, the constitutional principle here is the Free Exercise Clause. And the Supreme Court ruled that the family's right and interest in having their free exercise of their religion was more compelling and outweighed the state's interest in having compulsory school attendance. Alright, now we switch over to freedom of speech. We have two speech cases. First is Schenck versus the U.S. And here we have somebody who is protesting World War I, and they are encouraging people to resist the military draft. So that's the background, the facts of the case. The holding of the case is that the court actually ruled in favor of the U.S. government, because the U.S. government had passed a law known as the Espionage Act, which made it a crime to protest the draft and to obstruct military procedures. And the court here ruled that the Espionage Act was an appropriate use of Congress's wartime authority, that they did have the right to restrict that speech. And the constitutional principle that remains important to this day is that for the first time it allowed time, place, and manner restrictions on free speech. So this is a case that allowed the government to limit your free speech rights. On the other hand, Tinker versus Des Moines, this will expand free speech. The facts of Tinker were that a few students came to school wearing black armbands to protest the Vietnam War. And when the school told them to take off those armbands, they refused and they were suspended from school for doing so. So there's a couple questions in this case. Are those armbands, is that a form of protected speech? And secondly, do students at public school even have free speech to begin with? Well, the holding in this case ruled that yes, wearing armbands, symbolic speech, that is protected as pure speech. And students do have free speech in public school. So the constitutional principle, going right along with that, is that students do have a right to political, symbolic speech while they are at school based on the First Amendment's free speech clause. New York Times versus the U.S. is a freedom of press case. Now, what happens here is that the Nixon administration wanted to block the publication of the Pentagon Papers. These papers had been leaked to the Washington Post and to the New York Times, and they wanted to stop them from being published. And in this case, the holding was that the government does not have the right to block and prevent the Pentagon Papers from being published. So they rule in favor of the New York Times and against the federal government. Why did the Supreme Court rule this way? Well, because of freedom of the press, there is a heavy presumption against the validity of governmental claims of prior restraint. Prior restraint is another word for censorship. In other words, it will be really difficult for the court to ever rule in favor of the government when it's trying to censor somebody. Alright, next up is Gideon versus Wainwright. In this case, a Florida man was arrested and charged with a felony, and when he came to court, he asked the court to appoint an attorney for him. He was homeless, he obviously couldn't afford an attorney, but the judge refused, saying that state law said they did not have to do that. So Gideon appeals his case to the Supreme Court, and the court here holds that states must provide attorneys to people who can't afford one for themselves. The constitutional principle here is that it incorporated the Sixth Amendment's right to legal counsel. So it was already true, according to the Sixth Amendment, the federal government had to provide attorneys to people who couldn't afford one, but now because of Gideon versus Wainwright, states also must provide attorneys if somebody can't afford one. Roe versus Wade is a very famous case about abortion. The state of Texas had a law that made it a crime for a woman to obtain an abortion unless it was to save the life of the mother. The holding in this case was that a woman does in fact have a right to an abortion, and so states can no longer ban abortion because of Roe versus Wade. The constitutional principle for this case is the right of privacy. Now, the right of privacy isn't directly written in the Constitution anywhere, so there's no one amendment number I can tell you that that's the right of privacy. It's really a collection of amendments, so the court takes that right of privacy and now applies it here to the right of an abortion. A very recent case is McDonald versus Chicago. This is 2010. In this case, the city of Chicago effectively banned handguns. They didn't actually ban them, but what they did was they said you have to have a license. You have to register your handgun. But anytime somebody would apply for a license, they would invariably be struck down and deny that license. So there was effectively a ban on handguns. Well, here they ruled based on something they had just said a couple years before this. In 2008, the court had just determined that the right to bear arms includes for self-defense purposes. And so here they say that self-defense right with the right to bear arms, that applies to states. So the constitutional principle is that it incorporated the right to bear arms, the individual right to bear arms for the purpose of self-defense. So now the federal government, they can't take that away. That's already been true since 2008. But now with McDonald versus Chicago, states can no longer take away your right to bear arms either. Brown versus Board, a landmark civil rights case. The facts for this case is that black students throughout the country in many states, they were being denied the ability to go to schools based on their race. The court here held that racial segregation of public schools is unconstitutional. They overturned Plessy versus Ferguson, which had allowed separate but equal segregation when it comes to public schools and other things as well. And here the court strikes that down, at least in the area of public schools, so no more segregated public schools. The constitutional principle here is the 14th Amendment's Equal Protection Clause. And the idea is that those racially segregated schools, separate but equal, were inherently unequal, and therefore that inequality violates the Equal Protection Clause. And our last case is Citizens United versus FEC 2010. This is all about money in politics. So there is a law known as the Bipartisan Campaign Reform Act. It did a lot of things. What we're going to focus on is that it said that corporations and unions, they were not allowed to make political ads within 30 or 60 days of a primary or general election. The holding in this case, again, there's a lot of moving pieces to it, but a couple of main ideas. They strike down those timing restrictions, say that that's a violation of free speech, but they go beyond that. They say that corporations, unions, and interest groups, that essentially they are people, and therefore they have free speech rights, which allow them to spend as much money as they want in politics as long as they do so independent of the actual candidate. And the constitutional principle, I kind of already touched on it, but it's based on free speech. So these groups, these unions, these interest groups, and these corporations, they're allowed to raise as much money as they want. They can spend as much money as they want, affecting politics the same way an individual person can. They cannot give money directly to the candidate, but they can raise lots of money, and that's because spending money is a form of free speech. If you need more information on any of these cases, check out the videos I have for each case individually, even more details and all of that stuff. But until next time, this has been a LaMoney production. Thanks again for watching this video. I hope that it helped so much. Please make sure you hit that like button, subscribe if you haven't already. I have everything you need to get ready for this AP test. Check out the AP Gov Ultimate Review Packet. I have practice tests, study guides, tons of great content for you there. Make sure you guys check that out. I'll see you next time.